Good afternoon, all. This hearing is in the matter CFI 092-2021 and is being held by way of video conferencing before His Excellency Justice Lord Angus Glennie, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the Registry in Dubai on the judge's instructions. The claimants, Sandra Holding Limited and FAWZI Musaeed Al Saleh, are self-represented and absent from today's hearing. The defendants are represented by BSA Ahmed bin Hazim and Associates, LLP. Lead counsel is Mr. Martin Khoshtel. Thank you.
Mr. Khoshtel,
Yes.
the claimants do not appear to be represented, and they haven't turned up in person.
Correct.
Have they been, as far as you're aware, notified of the hearing?
Yes, because they have Mr. FAWZI Musaeed Al Saleh is the second claimant. He, I should say, is the director of Sandra Holding, and I think sole shareholder of Sandra Holding as well. So he has two capacities in this case, potentially. He has been in copy on the correspondence between the registry and ourselves, and therefore, by implication, he has been made aware of this hearing.
Yes, thank you. And the other one thing I wanted to ask you right at the beginning was, you're asking for an order for an inquiry into damages. Is that against all the claimants or just Sandra Holdings?
It's against both claimants, yes.
Both claimants, yeah. Very well. I've read your skeleton argument, and I've read most of the references you've given and some other material. How do you want to proceed?
Well, I was good. You may have seen within the skeleton argument, other than dealing with the facts, which we can come back to later, I had devoted some paragraphs to service of this application, which I don't know if you're on if your lordship has had a chance to review, and the supporting documents. But in a nutshell, I can summarize it in this way. Trowse and Hamlin's LLP represented the respondents to this application, claimants, in their original capacity, by email dated 31st of January 2024. That's at 848 of the bundle, where they say, this is Trowse, indicate that they are no longer representing the two claimants.
Yes.
There was an order, in fact, submitted or issued by the DIFC. I think that's at page 857 of the bundle, which crystallizes what I've just mentioned to your lordship. So, as of the date of the order, Trowse and Hamlin ceased to be the representatives. Now, the indication that Trowse and Hamlin's no longer represented the claimants came prior to the making of this application that we're dealing with.
Yeah. I
accept that the order, which formalized the position, came afterwards, but for all intents and purposes, and the effect of which is unaffected by the making of the order after the making of this application. So what we're dealing.
Sorry, just help me. You said that the order was made after the application was fixed.
Yeah.
Is that right?
That's right.
So they were on the record as legal representatives of the claimants at the time the application was fixed.
Correct. The application notice issue date is the 19th of March 2024. Service was effected respectively on the first respondent being Sandra Holding on the 2nd of May 2024.
Yeah.
Paragraph 19 contains the references in my skeleton argument to the supporting evidence. The second respondent was actually served after the making of the cease to act order. Paragraph 20 contains the references supporting that proposition. So service of this application was made on Mr. FAWZI Al Saleh on the 12th of May, which is 3 days after the order recording that Trowse and Hamlin ceased to act.
Yes.
But as I say, because the indication came on the 31st of January 2024 by email which is in the bundle at page 848, the defendants, i.e. the applicants, took the view to...
You've frozen a bit.
Sorry, can you hear me?
It's got it. Oh, still, I can't hear you. You seem to have frozen.
Can you hear me now?
That's better.
Yeah.
Yeah,
I'll try again.
Now.
Yes, I'll try again.
Can you repeat the last sort of minute or so?
Yes. So because the indication came on the 31st of January 2024 that trials no longer represent both claimants.
Right. Your microphone is, whether it's my network or yours, I don't know. But
is there an issue with hearing me, or is the issue with seeing me?
No, the issue is the words are breaking up.
Right.
And then when they break up, your face goes frozen.
Your Lordship, from the court side, we can see and hear Mr. Costello clearly. Should you wish, we can see and hear Mr. Costello clearly. I think the issue may be from your side. You may wish to perhaps disconnect and rejoin.
Should I go off and then join again?
I think that's the best, yes.
Yeah. Sorry about this, Mr. Costello.
That's right.
Can you hear me?
Yes, my lord. Can you hear me?
At the moment, I can. I'll put my hand up if I lose you.
Yes. Okay. I'll start where I left off just before your lordship told me I was freezing up. So what I was saying is, because trials indicated on the 31st of January by email that they no longer that they are no longer instructed by SANDRA Holding and Mr. Al Saleh, notwithstanding that fact and the absence of an order recording that they have ceased to act, or a formal order recording that they've ceased to act for the claimants, we, as the applicants to this application, took the view that it was prudent to serve the applications on the claimants themselves, as opposed to
as well as trials.
Not through trials, no.
No, did you serve trials as well?
No, we didn't serve trials.
That's fine.
But so that's the position where we say that, in fact, the whole point of this section was to give clarity to the court as to why the claimants have been served themselves as opposed to through trials and amendments, and to avoid any issues of service. So that's the first point. I've set out some of what I say are the pertinent facts at paragraph 7 through to paragraph 16 of my skeleton argument. I know that your lordship will probably be familiar with this anyway, because your lordship sat on in the Court of Appeal when hearing this judgment. But the pertinent facts that I have elicited from the judgment relate to the making of the ex parte freezing orders, which were on the 10th of November 2021, continued on the 30th of November 2021. Then what the claimants did was to take those freezing orders and seek to enforce them abroad, France and America.
The freezing order was granted in the DIFC in support of Kuwait proceedings. Is that right?
That's right. Yes, that's right. And
but the process in Massachusetts and France was processed based on the freezing order rather than the Kuwait proceedings.
Correct.
Yeah. Okay.
And in fact, the affidavits of Mr. La Liberté and Olivier Benlé support that proposition. So yes, On the 22nd of November 2021, the respondents sought to enforce the WFO, the freezing order. There were attachment orders issued. I've already set this out in summary within the skeleton argument. There was a similar application made in America before the Massachusetts court.
Yeah.
Some further events took place in between, but ultimately, the attempts to enforce in France and before the courts of Massachusetts were not successful.
Yeah.
And as we know, eventually, the Court of Appeal in the DIFC set aside the freezing order as well as the contempt of court. But for the purposes of today, the freezing order is the important aspect of this.
Yeah.
And any application that can be made before the court of first instance. So this is where we're at today.
Yeah.
The application was made on, as I indicated previously, on the 19th of March 2021. In support of that application, there was a third witness statement of Mr. Ahmed Al Saleh that begins on page 9 of the bundle. But more importantly, the signed affidavit of Mr. La Liberté, and that's at page 15 of the bundle, and Mr. Olivier Binder at page 573 of the bundle. I'll come back to those later if needs be, but I think what may be of more benefit at this juncture is to just go into the legal principles that are applicable to ordering an inquiry into damages. What is clear as a proposition at this stage is that there are two stages to an inquiry into damages. One is the actual ordering of the inquiry, and the second stage is the granting of damages.
Yeah.
There is some authority, and we can look at this in more detail soon, that a summary assessment of damages may also take place, but I'll come to deal with that in due course. So looking at, first of all, the first step, which is the ordering of the inquiry. I'm looking at paragraph 22 of my skeleton argument.
Right. Yeah.
So what I set out there is the wording of the undertaking,
Yes.
and I know that your lordship will be familiar with it, but just to set it out so it's clear on record that the undertaking reads as follows: if the court later finds that this order, being the WFO, has caused loss to the respondent and decides that the respondent should be compensated for that loss, the applicant will comply with well, it says comply with, it should say would comply with any order the court may make. So that's just a typo in the skeleton. So that's where the power to order an inquiry comes from. It may be by application by a party, but actually the relationship is between the court and the applicant of the worldwide freezing order.
Yeah.
There are a number of leading cases. Perhaps the most significant is the Yukong Line Limited case, which appears.
I read that.
I'm grateful. And the Malhotra case from the English High Court adopts the principles that are set out in the Yukong case. So we can look at the Yukong case, and where relevant, we can look at the Malhotra case. If we go to page 871 of the bundle.
Mm-hmm.
Helpfully, the court in the Yukong case has set out the relevant law as to an inquiry into damages. So the relevant paragraphs are 32 to 36. And I'm grateful that your lordship has already read those. But I've sought to summarize the pertinent principles within paragraphs 26 to 29, I believe, of my skeleton argument. The simple point is this, that where an injunction has been wrongly granted, even if there hasn't been any fault on the part of the applicant of the freezing order or the party seeking the injunction, then the ordinary position is that the court will order an inquiry. But the court will only order the inquiry where it appears to the court that loss may, and it's my emphasis on the word may may have been caused as a result. And that comes from paragraph 33 of the Yukon case, page 872 of the bundle.
Yeah.
Paragraph 34 states, where the court has lacked jurisdiction in granting the injunction, then it is difficult, quote unquote, it is difficult to envisage any circumstances in which the court would refuse to order inquiries to damages upon some evidence of loss. And within paragraph 34, that is just under the Hoffman citation.
Yeah.
I don't know if your lordship can see that. Paragraph 35 of the judgment, of the Yukon judgment, states that there must be some credible evidence that he being the respondent to the freezing order or to the injunction has suffered loss as a result of the making of the order. And that's in the first sentence, I believe.
Yeah.
Again, and then it goes on in the second sentence to state the court will not order an inquiry if it appears to be pointless to do so because the intended claim for damage is plainly unsustainable. That may be because it is clear that the order is no more than the factual context for loss, which would have been suffered regardless of the granting of the order. Or it may be equally be clear that the damage is too remote. That's important because what we say is the losses that presently have been provided to the court were the context of those losses is the attempt to enforce the WFO. And so it's an obvious point, but it's a point nonetheless that needs to be made. But for the granting of the WFO, there wouldn't have been enforcement proceedings of the WFO. So it's a circular argument, but it's a point. It's an argument which makes clear what this sentence means. So, and the losses have been suffered as a result of the granting of the WFO. Now, we are currently, in my submission, at the application stage for the inquiry into damages. And what is further said at paragraph 35, picking up from the sentence where we left off, right at the bottom of page 872, beginning with however, at the stage of exercising its discretion whether to order an inquiry, the court does not ordinarily hear protracted argument on whether the suggested loss will be recoverable. If the defendant shows that he has suffered loss which was prima facie or arguably caused by the order, then the evidential burden of any contention that the relevant loss would have been suffered regardless of the making of the order in practice passes to the defendant and an inquiry will be ordered. So this is also why we say there are two stages. This is the first stage. We are at the application stage. We seek leave from your lordship for an inquiry into damages, and at this stage, you do not normally hear protracted argument on the recoverability of losses. You just need to be satisfied that there is prima facie evidence of loss.
Yeah.
And that's and the evidence of loss comes from the affidavits I've mentioned previously.
Yeah.
There is also just to finish up on Yukon. Paragraph 36 goes into the question of remoteness of a claim for damages, but that might be something to look at later. Perhaps it's worth highlighting that it's stated in the Yukon case that the principles to be applied are those relevant in a claim for breach of contract. That's in the middle of paragraph 36, following the citation of Cheltenham and the loss of the building society.
The Court of Appeal in Yukon doesn't necessarily adopt that. It notes that as one of the tests, one of the approaches, and then it's been questioned, but it's not necessary to go into it.
Well, I accept that, but there may be some force in whether that is the appropriate test. I think that,
It doesn't matter.
Well, it doesn't matter at this stage. It certainly doesn't matter. Yeah, it certainly doesn't matter at this stage. I think what the takeaway point is that there is a lot of flexibility and discretion afforded to the court when assessing losses. Again, as I say, this may be a point for another day to be looked into. But for today's purposes, as long as you're satisfied, the court is satisfied there is prima facie evidence of loss with a link to the WFO, then that's enough for the inquiry to be ordered. At paragraph 30, I look at the Société Générale case, which I have cited at paragraph 30 of my skeleton, but the paragraphs within the judgment to look at are found at pages 911 to 913 of the bundle.
Yeah.
Paragraphs 43 to 45. I don't know if your lordship has already had an opportunity to read these. It spreads over just over 1.5 pages. Essentially, I've tried to summarize the point. The application needs to be made promptly, and there is promptness required in the prosecution of an inquiry as well. Now, in that case, the application for the inquiry into damages was made 8 years post-discharge. That's at paragraph 45 at page 912. Now, we're obviously not in that territory, but again, there is a degree of flexibility and context to be taken into account. As I've stated at paragraph 31 of the skeleton, this application that your lordship is dealing with was made approximately 6 months after the Court of Appeal in the DIFC allowed the appeal to set aside the worldwide freezing order. And so my suspicion, it is sufficiently prompt in the context of losses that have been suffered globally, requiring the gathering and assessment of evidence and documentation. There is also an exercise of us, as in the legal team, having to assess all potential heads of loss and deciding which is recoverable and which isn't recoverable. And that is obviously a two-way street with the client or the applicants. So in this case, where it's particularly complicated, given the global nature of this case, I don't think there can, in my submission respectfully, there can't be any criticism made as to timing.
Yeah.
And the final point I make at paragraph 32 is that the jurisdiction to be exercised is an equitable one. And that really does afford a lot of discretion to the court. And my authority for that is found at paragraph 34 of the Yukon case. I'm not going to ask your lordship to turn that up again, but it's also it also derives from the Hoffman case. That is at page 982 of the bundle. And
what paragraph of your skeleton were you on?
32.
32. Yeah.
I'll just read out the reference in the Hoffman case. As I say, page 982. And when your lordship turns it up, you'll see that there are letters, not paragraph numbers, but letters. And you'll see next to the letter D, the relevant paragraph.
Yeah.
Just trying to find the relevant. I've just lost it at the moment, but yeah. Contempt of court, etc. It retains the discretion not to enforce the undertaking if it considers that the conduct of the defendant in relation to the obtaining or continuing of the injunction or the enforcement of the undertaking makes it inequitable to do so. But if the undertaking is enforced, the measure of damages payable under it is not discretionary. It is assessed on the inquiry into damages. Principles are fixed and clear, etc., etc. And then it again refers to contract, but we're not dealing with that today. Anyway, the point here is that cumulatively looking at the two cases, your jurisdiction is an equitable one. So that deals with the principles as to whether an inquiry should be granted or not.
Can you just help me on one point?
Yeah.
Going back to the Yukon case and the passage you cite in paragraph 27 of your skeleton, where the court lacks jurisdiction, it's difficult to envisage any circumstances in those circumstances in which the court would refuse to order an inquiry as to damages.
Yes.
Are there any cases where the court has granted an order subsequently found to be lacking in jurisdiction because the court has misinterpreted its powers? Yukon is different because the Yukon says the court lacked jurisdiction because there was no good arguable case.
Mm.
What about where the court orders a worldwide freezing order in circumstances where the court had no jurisdiction to do that? In other words, it's the court's fault to some extent, rather than the party having misled the court.
Well, I mean, it's a bit more nuanced than that because one of the arguments that can be made is the party seeking the worldwide freezing order ought to have never made the application in the first place, whether it's due to jurisdiction or whether it's due to, let's just even say there was jurisdiction, but there was no reasonable prospect of even obtaining the injunction because, for example, as in this case, there's no link to Dubai, let alone the DIFC. So I'm not relying heavily on the point in paragraph 27 of the skeleton, which is paragraph 34 of the Yukon case. And I haven't found cases that deal with that nuanced scenario that your lordship has just thrown at me. But in my submission, I'm not sure it matters too much because ultimately the claimants attempted to get a worldwide freezing order in order to support, one, the Kuwaiti proceedings itself, and two, to enforce it in other jurisdictions where it shouldn't have even come to the DIFC for one reason or another. It should never have come here whatsoever. So even if the court made an error on jurisdiction, it's still I would say that the claimants
is an error the party itself has to.
Yeah, exactly.
Has to pay.
Well, that's the point of the undertaking anyway, because it doesn't really matter why it's set aside. There may be some question marks over the amount of losses. I can see that argument, the assessment of damages, but although I don't think that's necessarily applicable in our case, but I can see that argument being the point there. Unless your lordship had any other queries in respect of the test.
No.
So the credible evidence of loss. I appreciate your lordship has already indicated that you've read the relevant affidavits, and I think
there's a Massachusetts lawyer who talks about legal fees in Massachusetts being irrecoverable.
Yep, exactly.
And the Paris lawyer explains there's very limited recovery of legal fees.
That's correct. And in fairness, Mr. Binder has applied the appropriate credit where the French courts...
9,000, yeah.
Yeah, your lordship has the point. So how
much is the Massachusetts lawyer putting forward?
I'll just get that information.
I've forgotten.
Yeah, so I'm afraid so
page 18 or so of the bundle.
Yeah, I'm here, but I think it's actually one of the exhibits. I'll just get the exhibits up. Yeah, we've got. So if your lordship looks at 572 of the bundle.
Can I just see in his affidavit first?
Yes, of course. So he deals with it at JL. So it's the reference to JCLL4, which is at paragraph 12 of his affidavit, page 19.
Oh, I see. Yeah.
And JCLL4 is at page 572.
And what currency is that?
Dollars, because JCLL3 is the exhibit which itemizes the invoices. So if your lordship looks at paragraph 10 of his affidavit.
Hold on. Hang on a sec. So I just got to...
Yes, of course.
What page is paragraph 10
on? Page 19.
Yep.
So paragraph 10, he explains that the invoices have been compiled into JCLL3, and JCLL3 is at page 499 of the bundle. And your lordship will see that the current...
Hang on a second, sorry,
yes.
my reference is wrong. 572 was what? JCLL2?
572 is JCLL4.
And that is what?
That is just a simple table outlining the invoice number, the invoice dates, and the invoice amounts. And the invoice amounts in total come to $574,401.25. And I was just trying to assist your lordship to explain why I know that's in dollars, because JCLL3, beginning on page 4.
Yeah.
Yep.
Yeah. And that's 499.
Yes.
So the amount you presently would be claiming in respect to the Massachusetts proceedings is that $574,000.
Yeah, that's right.
Yeah. Okay.
And Mr. Binder has helpfully set out at page 579, which is paragraph just above, paragraph 25 of his affidavit, the total amount being claimed by way of fees and disbursements.
So what paragraph?
Paragraph 25
Of
of Mr. Olivia Binder's affidavit, which appears at 57, starts at 578, but
oh,
the
sorry,
main,
that's the wrong one. Yeah.
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 But 580. So that's his calculation, page 580 of the bundle. The total amount claimed from the French proceedings is 46,071 euros.
Yeah.
96. Yeah. So those are the current losses at present. Now, if the court is minded, in my submission, there can be a summary assessment, but we're to an extent we're in your hands now. As to summary assessment, I think it was the Yukon or the Malhotra case actually, which deals with the potential for it, but it's not something I press today.
Well, I should tell you my thinking on this.
Yeah.
It seems to me that yes, there is probably power to make a summary assessment, but I don't think you can pick and mix. I don't think you can have part summary assessment and part full inquiry.
Well, I understand that totally, and as I say, I'm not pressing that. So I accept that. I'm not going to push it any further.
Because you want to keep open the possibility of a bigger claim, is that right?
Yeah, well, that's also correct.
Yeah.
Now, in that context, it would be of great assistance to us if we can have directions today for, say, for example, all final I can provide a draft order once I've probably formulated the wording, but the effect is that a specific time period, which we can discuss now, for the applicants to provide all of their losses to the court, and then a further hearing to deal with losses.
How long do you need for that?
Well, I think, can I just put myself on mute and just discuss it with my colleague for 1 moment? There's something that occurs to me which I just need to quickly discuss.
Yeah.
My lord, I've just had a discussion with my colleague. One of the heads of loss has been a bit difficult to in terms of gathering evidence because there's been corporate restructuring. That means trying to nail the right individual down to give an affidavit has been very tricky. So in the circumstances, I asked for 8 weeks.
That's quite long.
Well, I thought I might be met with with some resistance. No, certainly no less than 28 days, but if we can compromise
my instinct was 4 weeks.
Well, yeah.
And you, as you've pointed out already, you haven't delayed overly long, but you still, it's been some months.
Yep, I accept that. So for 28 days would be the 26th of March. And I'm happy to, I'm not going to push against that. So the order would, there is a draft order in the bundle, but it needs to be revised because.
Where is the draft order?
Page 5821.
821.
Yes.
I see. It's not very helpful.
No, exactly. I accept that. I think that was written at the time where the application was being made, as opposed to well, not quite knowing whether there's going to be engagement from the other side or not. Anyway, I'm happy to rewrite this order, but if I can clarify that I would suggest that the recitals just need to add that Your Honour has heard from me today.
Yes.
Sorry, I'm just getting a pen. And then order 1, I think, is fine.
Can you just help before you get to order 1?
Yes.
If you just look at the pons for the moment.
Yeah. Oh yes, the application.
The one at the top of 822.
Yeah.
Reviewing the witness statement of Mr. Al Saleh, submitted on behalf of all defendants, noting there is further evidence forthcoming. What does that mean?
The reference to that is on page. I'll give a specific page reference in the paragraph so that Your Lordship can see where that comes from. That's on page 13 of the bundle, paragraph 19.
Yeah, what does he say?
He says that in addition, there were some additional losses incurred which require further investigation to ensure that the proper amount is claimed. To that extent, the defendants reserve their right to present to the court the full extent of their losses, including special losses as well as general losses.
Well, I think that paragraph of the draft order ought to stop with on behalf of all defendants, leave out the noting there is further evidence forthcoming.
Yeah, yes, I accept that. Okay. Then there is the review of the affidavit. There's the review of the affidavits. Sorry,
that's
plural.
Right.
Yeah.
Yeah.
Part 23, but also, and upon hearing from counsel, needs to be added. I don't know if Your Lordship wants to include a citation as to the review of the bundle. I don't think that there's any need for that.
No need for that.
No. And then it is ordered that there be an inquiry into the losses sustained by the I'll just change that to the applicants to keep it consistent.
Yes.
And then paragraph 2b, the applicants are to, well, I'll word it and then the court can amend it.
Hang on a second. In the first upon, you call them the defendants.
No, I'll change all of that. I'll change the application
notice of the.
I'm going to change all references.
I didn't mind whether they're applicants or defendants, provided it's consistent.
Yes, okay. I understand that. And I'll add the date of the application as well.
Yeah, and perhaps the registry will have a view on whether it should be applicants or defendants.
Yes. Well, what I can do is just write applicants stroke defendants and let the registry decide which they prefer.
We'll have to go into the heading as well.
Yes.
Right.
Yes. And then so we go to order number 1.
Order 1 is fine. Is that the way the order is framed normally?
Well, I think there are various permutations, but as long as it captures the point, then it could be.
Normally, it's an inquiry into damages, isn't it?
Yeah, as opposed to losses. So there'd be an inquiry into damages sustained by the applicants stroke defendants. And you can just stop there.
Yeah.
And then 2 would be.
No, it can't stop. It's got to have as a result of the WFO granted by the court on whatever date it was.
Yeah. Yes.
And then directions would be by 26 March 2025.
Yes.
The defendants stroke applicants.
Yep. To submit.
Submit a
all evidence.
So no, so you want the claim to be set out too, as well as the evidence. Submit a detailed claim setting out the losses sustained by them. So, sorry, setting out the damages claimed by them to to have been suffered as a result of the WFO, something like that.
Yeah, I'll get I will consider the wording and make sure it's appropriate.
But so it's a single claim accompanied by any evidence to be relied upon.
Yeah.
In support of that claim. And I think for the avoidance of doubt, when you come to do that, you should refer to the existing affidavits of Mr. Liberté and Mr. Binder, as well as any other material.
Yes. There is a question as to service.
Yes, I was going to say you should add a new paragraph 3, I suppose, providing that the itemized claim is to be served on, and the evidence is to be served on the claimants.
Yes.
Personally. And I should probably, for the avoidance of doubt, just to be safe, put in the addresses at which you intend to serve them.
Yes. Yes, I think in relation to Mr. Nouri, because he resides in Kuwait, service is by a court process server, and in Kuwait it's by email. But anyway, it maybe I just need to or set that out in clear detail.
Yep.
I think then it's just well, I say cost in the case, it should be cost in the application, I suppose.
Cost in the application, yeah.
I don't think we should set a return date because, in fairness to the claimants, once they are served and because they're out of the jurisdiction, there is an extended period of time for them to potentially respond. I accept they have not been responsive to date, but I have to operate on the basis that there's always a possibility.
Assume they may change their minds.
Yeah. Albeit they may be limited to just dealing with the evidence of losses and damages, but anyway, that's something for later. I'm not.
At what time? Sorry, just help me on this. At what time does any argument about remoteness, for example, come into play? Does that come in at the next stage?
Yes, because it's whether the damages are too remote or otherwise. This is the main point of this hearing is whether to order the inquiry, which I take it that your lordship is minded to order the inquiry.
I'm minded to order the inquiry. Yeah.
Yeah.
If you work out the terms of an order, as we've been discussing, I will add a few paragraphs of reasons.
Yes, I understand. What I was thinking of is whether within the body of the order there needs to be provision for a return date, but I'm not sure that's necessarily a good idea, other than perhaps a general boilerplate clause to allow the registry to liaise with the parties with respect to fixing a return date hearing.
I will ask Reem, or Haley, is that a sensible course?
Yes, Justice Glennie, I see no concern with using the standard wording as Mr. Coshdale suggested.
Right. Thank you.
Okay, well, I'll make that number 4, and number 5 will be costs. So number 4 will be the return. All right.
And I suppose you could reserve costs if you prefer. It doesn't really matter.
It doesn't make a difference. I'm happy to say cost reserved.
Maybe cost reserved at this stage, just in case they come back and say that there's been some mishap.
I agree. Yes, no, I see.
Right. Okay. but I'm prepared to grant an order substantially in those terms.
Yes.
If I can ask Reem or Haley just to, if they're happy with, if there's any query they have about the general shape of the order.
As of now, no concerns, but let's wait for the draft to come in for our further review.
Yep, that's fine. Thank you.
My lord, I should say, having just reviewed the recitals for the order again, I'm minded to suggest that we include something about service of the application and the non-attendance of the claimants within the recitals.
Yes. So it's means of how the defendants were notified of the hearing, and the fact they haven't appeared at the hearing.
I think it's service of the application, notification. So one notification, service of the application. 2 is notification of the hearing. 3 is the non-attendance of the claimants.
Yeah.
I think that's everything.
But I'm sure you'll be put right if you produce a draft which doesn't have everything.
I'm sure it's happened before.
It's happened to all of us, don't worry.
Yes, of course.
Okay, and then as I say, I'll add a few paragraphs of explaining my reasoning in granting the order.
Thank you very much.
Is there anything else that you need to mention before we stop?
I'm just going to look over to my colleague just to make sure. No, no. Thank you very much.
Very well. Thank you very much. It's quicker than anticipated in the thing, but of course we didn't know who was going to turn up.
Exactly.
Yeah.
There could have been a protracted argument on anything to do with the inquiry, whether there should be a leave or not. So that's why we indicated 4 hours.
Yeah, that's fine. Right. Well, thank you very much, and I'll make an order substantially in those terms, and you'll get it within a short period after this hearing.
Thank you very much.
Thank you very much. Thank you.
Thank you all.